Welcome, everybody. Thank you for joining us for our sixth and final session in our 2021 speaker series, Taking the Digital Welfare State to Court. My name is Jonathan McCulley, and I am DFF's legal advisor. With me behind the scenes are my colleagues Judith Rauhofer, DFF's legal officer, and our events team, Jahan Jadran and Claire Eichholzer. Together, we will try our best to ensure that this webinar goes smoothly and we do not succumb to any technical difficulties. To give you all a bit of a background to the series, for those of you who haven't joined us so far, over the past 2 years, the protection and promotion of human rights in the context of the digital welfare state has been a major focus for our work here at DFF. And we have seen across Europe an increasing desire by governments to digitize the provision of social security and other vital public services. And this has often been driven by their desire for efficiency, cost cutting, and fraud detection, and has been at the expense of civil, political, economic, and social rights. And these themes have been discussed across many of our workshops and events, like, for instance, our Litigating Algorithms workshop in 2019. We've also held a number of one-on-one and group consultations with a range of organizations working on the topic. And based on these consultations, we have produced a strategic document to inspire conversations on how strategic litigation could be used as part of a broader strategy to address the harms of the digital welfare state. You can find that document and more information on our activities in this area on the DFF website. And we also continue to engage with a range of other organizations that might not yet be part of the DFF network on this topic, including racial, social, and economic justice organizations, as part of our ongoing Digital Rights for All project. Our objective here is to provide a space to the people most affected by the harmful use of technologies and who are often missing from digital rights policy circles, to develop and implement their own agenda in how to challenge these technologies through advocacy and litigation. And this year's speaker series seeks to complement this work by exploring a range of cases from different jurisdictions and relating to a range of different digital welfare state issues to show how strategic litigation can be used by and in collaboration with these communities to protect their digital rights. So far, we have heard about the use of biometric ID systems, profiling algorithms, data-driven fraud detection models, automated needs assessments, and the increasing role of private companies in providing digital solutions in welfare contexts. And these conversations have highlighted the global trend that is digital welfare, with examples from Poland, India, the US, the Netherlands, and South Africa. And today we'll be traveling to the UK, and we'll be discussing the topic of miscalculating income, taking on digitised universal credit in the UK. And over the course of the next 50 minutes or so, we'll be hearing about a case that truly highlights the unfairness and hardship that can be caused to people's lives by the application of rigid and inflexible mathematical rules to human need. The UK's social security payment system, universal credit, has been heavily criticised for failing those who are facing or living in poverty. And policies aimed at making the universal credit programme digital by default have only added to individuals' distress by further exacerbating volatility and uncertainty in their welfare payments. In 2018, the Child Poverty Action Group represented 3 working mothers in taking a legal challenge against a method of calculating income that arbitrarily left them without the full welfare payments they needed and were entitled to. And we are joined today by Carla Clarke from the Child Poverty Action Group to talk about the case. Moderating the conversation is Amos Toe. Carla Clarke heads up the strategic litigation work at Child Poverty Action Group and has led complex public law cases in the social security field through all stages of the court system. And prior to joining the Child Poverty Action Group, she worked at the government legal department in various litigation and advisory capacities, and also at Minority Rights Group International, where she engaged in litigation and advocacy work on the rights of Indigenous populations and ethnic minorities. And Amos Toe is Senior Researcher on Artificial Intelligence and Human Rights at Human Rights Watch, and he leads the organization's efforts to document the impact of AI and other data-driven technologies on poverty and inequality. Thank you both for joining us. And just before I hand over to Amos, who will kickstart the conversation, I just want to give you a bit of an overview of what this next 50 minutes or so looks like. So we'll spend about 30 minutes hearing from Carla about the background to litigation and what it has achieved. And while they're talking, we encourage all of you out there in the Zoom darkness to use the Q&A function that you can find on the bottom of your Zoom screen to ask what any questions you might have for Carla and Amos. We'll have about 20 minutes towards the end of the webinar to allow Carla and Amos to consider your questions, answer as many questions as possible. And we just ask that please do submit your questions when they come to mind during the conversation. No need to wait to the end. We know how frustrating it is to kind of sit on a question for 15 minutes or whatever and try and remember it when it comes to Q&A time. And thankfully, Zoom allows us to ask our questions rather immediately. So do please use that function, and we'll make sure that we can answer as many of those questions as possible. I'm going to stop talking now and hand it over to our moderator and our speaker. So on that note, and without further ado, Amos, Carla, the floor is yours.
Great. Thanks, Jonathan, for that great introduction, and welcome everyone. Hi, Carla. How are you?
Good. Got children in the house, so we've just come home from school. It's 4:00 in the UK.
Oh, awesome. So maybe we can just get right to it. And for people who aren't familiar with the UK social security system, I was wondering whether you could explain what universal credit is and how it works.
Sure. So universal credit was flagship welfare reform policy of the Conservative coalition government in early last decade. And it's the idea that the universal nature of it is replacing 6 means-tested welfare benefits. So it's a mean-tested benefit. You have to, your income has to be below a certain amount in your capital in order to get it. And the idea, the attraction behind it was, rather than dealing with 6 different claim forms, that you'd have a simple process. It'd be a single claim form, and it would be digital by default. And the emphasis on digitization in terms of efficiency, in terms of saving money, in terms of simplicity, in terms of also reducing fraud and error, as Jonathan mentioned earlier. So somebody makes a claim for universal credit, and their entitlement is determined by reference to what's called an assessment period. So it's a monthly assessment period. It's not a calendar monthly. It depends when you make your claim for universal credit. So say I claimed today, the 1st of December, my universal credit assessment periods will run from the 1st of December to the 30th or the 31st of the month. And then at the end of that period, a person's entitlement is assessed by reference to their circumstances in that assessment period. So it's paid in arrears. So you can get a maximum amount, which is made up of an element for you as an adult, for any children you have, for any housing costs, for any additional elements for disability, for example. That gives you your maximum, the potential maximum amount. And from that is deducted income. So there's something called unearned income, which is other benefits that you might be receiving, non-means tested. Those are deducted pound for pound. And there's also a deduction for any work that any income from work. But because one of the ideas of universal credit is to encourage people to get into work and to end welfare dependency, the amount that you earn from work is not deducted pound from pound. You get something called a work allowance, which is a certain amount that you can keep before it's taken into account for the purposes of universal credit. And then the rest of the amount is subject to a taper. So it used to be, prior to changes last month, used to be a 63% taper. So for every pound you earned, 63p was taken into account for universal credit. And so that income is deducted from your maximum amount, and that gives you the actual amount that you receive in that assessment period. So that happens on a month-by-month basis, on an automated basis via the UC system.
So as you've mentioned, one of the main elements is means testing based on income. And we've both looked at this issue of what has gone wrong and is still going wrong with the way in which the Department for Work and Pensions, which is the government agency that administers universal credit, the DWP, how they miscalculate people's income in arriving at people's monthly benefit payment. Can you explain what the problem is?
Yeah, so there are quite a few problems, but to try and explain it as easily as possible, hand in hand with the establishment of universal credit, which is, as you say, is administered by the Department of Work and Pensions, there were changes made to the way employers report earnings to Her Majesty's Revenues and Customs, so essentially our tax office. So whereas that used to be paper-based and it used to be annual returns, again, at the beginning of last decade, it became an automated process, and it's called real-time information. So every time an employer pays an employee, they fill out an online form which sends lots of information to the tax office. So if somebody's paid weekly, every time the employer pays them, an RTI feed is what it's called. So real-time information feed is sent to HMRC. If you paid 4 weekly, it would happen on a 4-week basis. If you paid monthly, it'd be paid on a month basis. And so that contains lots of information for the purposes of tax. But the HMRC, Tax Office, and DWP, Department of Work and Pensions, the idea was that there would be a direct feed from the information that the tax office holds to the universal credit system. So the universal credit system would know how much somebody had earned in real time. And that information could then form an accurate basis for assessing what their income was in any given assessment period. So it's not dependent on individuals reporting what they're earning. It's an automated system. And the idea that would remove fraud, would remove error, and would make it simpler for both individuals and employers. The big problem with that is to make it as simple as possible and to allow for automation. A single input is going through to UC in terms of what your earnings are. And that is, bringing together any earnings that have been reported by your employer. And that is dependent on how much you actually receive in an assessment period. So various situations that somebody might have done work 6 months ago, but they're not employed, then they're not paid until this month, and it's that the earnings will show up in this month for something that was done 6 months ago, because it's dependent on this RTI feed and the amount that's actually received. That's a simplistic issue that's raised. We can go into the actual case, the Johnson case, in more detail and talk about the issue raised by that, and then other issues about people who are paid 4 weekly or 2 weekly or weekly, and problems that are raised because of this dependence on not just how much you work, not even how much you earn, but actually how much you receive in a particular assessment period.
And so, just before we get into the case, which is a really interesting case, I'm just wondering, at the moment that the government decided to link up RTI to universal credit calculations, did civil society organizations as well as other independent observers, did they actually flag that this was going to be a problem going forward? And what was the government's response?
You can correct me on that, Amos, because I'm a lawyer, not a policy person. But I don't think it was, I've spoken, for the purposes of this case, we spoke to payroll experts, yes, and the payroll people were sitting around the table with the tax office and saying that there were potential issues here. And the tax office was taking that on board, but DWP was pushing because it wanted to roll out universal credit very quickly, even though 10 years on, we're still waiting for it to be fully rolled out. UC was pushing for things to be put into the RTI feed, RTI, real-time information, to be put in place as quickly as possible. So some of the issues and concerns that were being raised were not being addressed. Yes. So it's not as though some of the issues were not new to them. And then one of the other problems is there's a big disjunct, it's a compartmentalization of government. And what HMRC does and what information it wants for its purposes, and not necessarily what DWP wants for its purposes. And sometimes just not sitting at the same table, or if they are sitting at the table, speaking at cross purposes. So there were concerns being raised, but I don't think it was fully taken on board the full extent of some of the issues that would start coming through, because of what DWP felt that, okay, monthly assessment periods make sense because majority of people, which is the case, are paid monthly. There are issues in relation to people on, means tested benefits, the type of work that they are involved in. There's still monthly payments, but there's also a considerable amount of, pay as you earn, or pay as you work, and then 4 weekly, 2 weekly pay. So it's not as universal to have monthly payments in the low pay sector. But DWP's view was, well, we want monthly assessment periods because that reflects the majority in work. And we want to encourage people to get used to working, even though universal credit is a benefit for both those who are in and those who are out of work. And we want to encourage people to budget, etc. And a lot of outgoings are done on a monthly basis. So in some way, electricity bills, gas bills. So quite a patronising view that we know what's best for people, and we want to align them to how we, civil servants and government ministers, how we are actually paid and budget ourselves.
Great, yeah, that's very insightful. And so, fast forward to a few years ago, and CPAC worked with Lady solicitors to file a challenge against this particular aspect of the universal credit system and the miscalculation of income. Can you explain how that came about?
Okay. So, as I said, there are various inconsistencies and issues that are brought about by this reliance on actual earnings received. But one of the first ones that came onto our scene was at the end of the 2017s. So, although universal credit was on the books since 2013, it was rolled out gradually. And in 2017, there was much greater push to try and get more people onto universal credit. And so we started seeing more issues coming through. And one of the issues that was coming through were people who were in regular monthly employment, but relatively low paid and needed, means tested benefit to top up their payments. So in fact, the clients that I worked with were all single mothers, one of the sectors, one of the groups who are more likely to need top up to how much they're earning themselves. And the issue that one lady who got in touch with me raised was that there were times when her universal credit award, which she was expecting to be regular month in, month out, because she was in regular paid employment, her circumstances weren't changing in terms of 2 children at home, in terms of how much the housing costs were. So she was expecting a stable amount of universal credit to go alongside a stable amount of monthly earnings. And every now and again, she noticed that her universal credit amount dropped quite considerably, to be then followed by a high amount the following month. And when we investigated this further, what was happening was that every now and again, she was being treated as receiving 2 lots of wages in one assessment period. And this happens for those people where there is a clash, for want of a better term, a clash between their assessment period start and end dates and their pay dates. So the particular lady in question, she happened, purely arbitrary when people claim universal credit, she happened to have claimed universal credit on the 30th of the month. So her assessment period ran from the 30th of the month to the 29th of the following month. She was paid by her employer on the last working day of the month. Yes, the last working day is going to vary, month to month. Sometimes the last working day will be the 30th and the 30th. So she'll get one assessment period. She's earned on the 30th, no more earnings in that period. Universal credit is based on one monthly pay. But every now and again, the last working day might be the 28th or the 29th. So she's been paid in 1 month on the 30th. In the following month, she's paid on the 28th or the 29th. And both of those come through the real-time information feed and are picked up in that 30th to the 29th assessment period. And she's treated as receiving 2 lots of wages. And of course, the reality is that the fact that she's been paid slightly early doesn't mean that she's received double whammy in 1 month. Yes. So she still had, she still was earning the same amount, still had the same amount of outgoings, but she suddenly had a much lower universal credit award, which was then impacting on her ability to pay rent, to pay other outgoings. And some people, listening might think, well, okay, that is an issue, but doesn't it compensate itself in the following assessment period when she's treated as receiving nothing? And the response to that is that in terms of the oscillation, it doesn't compensate. Yes, even if the net same amount was received over a period of months, the oscillation for people who are living right on the edge, what comes in goes out. These people do not need budgeting support. They know their budgets and they know their incoming amounts and outgoing amounts much better than I do because they've got no safety cushion. But in addition to the fluctuations, I mentioned when I was describing universal credit at the beginning, this idea of a work allowance. So in each assessment period, you're able to hold on to a certain amount of your earnings. But if 2 monthly earnings are grouped together in one assessment period, and then you're treated as having no earnings the following assessment, you only benefit from 1 work allowance. Yes, rather than if you have 2 monthly wages in 2 assessment periods, you'd be able to hold on to 2 lots of the work allowance. And the work allowance at that time was worth £192. It went up during the course of the litigation to £293. And now, as of last month, it's now worth £335. So it's a considerable amount of money that people are allowed to hold on to. And my clients were not being able to see the benefit of that purely because of when they'd claimed universal credit. So one of the clients, she tried herself to find a workaround and she said, okay, I will end my UC claim. Yeah, so I'll end my UC claim and I'll start another UC claim and I'll do it in the middle of the month. I'll do it from the 15th. I'll do it on the 15th. So my assessment period should run from the 15th to the 14th. And there's no way that it will clash with when I'm paid on the last working day of the month. She tried that, but the way universal credit works is that if you've made a claim, that's essentially runs in the background for 6 months. Yes. And if you reclaim in that period, all your same details remain the same. So if she really wanted to be able to start a new claim with different assessment period dates, she'd have to wait for 6 months. And of course, she couldn't wait for 6 months because she needed the money. She tried to get her employer to pay her on an individual basis at a different time of the month. So not the last working day of the month. And of course, her employer was a city council employing, hundreds, thousands of people, and it wasn't prepared to do a bespoke run just for her situation.
And, one of the things that is particularly striking from your description is this idea of what goes in comes out, right? That people really are living from paycheck to paycheck. And can you explain kind of how she coped with or didn't cope or struggled to cope with these oscillations in UC payments, as well as kind of the overall reduction because of the withdrawal of the work allowance for some months?
Sure. So, articulate lady had always worked. She found herself having to resort to food banks to be able to tide her over. We had 2 other clients as well. In the most extreme circumstances, one of the clients, attempted suicide on 2 occasions just because of the sheer overwhelmingness of I'm working, I'm trying to provide for my son. You, the system, are just throwing everything I'm trying to do out of zinc. Yes, and the inability to get through to people. One of the things with universal credit is that it's very hard to get through to a helpline. The emphasis is on posting things on your journal. This is an online journal. And you can see people post things, saying, can you try and address this? And you get a response maybe 5 days later. Yes, even further down the line than that. So there's a delay in responding. And when responses are done, they're by call handlers who don't necessarily know the ins and outs, and they often don't respond directly to the question. So because of the sheer overwhelm and frustration, getting herself into debt, not being able to pay her rent, she attempted suicide on 2 occasions. The third client that I had, she was in a situation where she had to choose between paying her rent or paying her childcare costs whenever this happened. She got to a situation where her landlord came round to essentially say, well, this has happened too many times, you're going to be evicted. She tried to explain to the landlord what's happening. The landlord supported her in phoning UC to try and explain the situation to them. But it got so stressful for her, particularly when you're on your own as a single parent, trying to deal with your work, your child, and this on top of it. It got to a situation where rather than having this fluctuating income, she felt it'll be much better for me in terms of my stress level if I have a stable income, and that will be through not working. So she resigned. Yes, UC is meant to be about incentivizing work, getting people into work, making sure work pays. For her, she felt it was simpler to have a slightly lower income, but she knew where she would stand. She would know how to budget for that, rather than this, sort of arbitrary thing that she felt she couldn't control. So it's, I'm talking to the Zoom darkness, as Jonathan described it, but it's trying to get across the impact of this on individual people and their lives. It's not just an algorithm. It's not just an automated calculation. These are real people facing really distressing circumstances because of the universal credit system and an oversimplification of it. Yes, it was the idea of making it more simple. It's not more simple for the individuals. It's more simple for the government department operating it.
And before we get into the actual kind of meat of the decision, I just want to remind everyone that if you have a question, please put that in the Q&A function. I'm sure there are many. Carla, one of the things that, it was so compellingly detailed in the case, the kind of hardship that the claimants and generally people with this problem experienced. But the government took a really hard line in the case about and essentially said that we need to set bright line rules. The automation serves an efficiency purpose, and there will be a few edge cases where people experience hardship, but we need to essentially make some sacrifices, or certain people need to make some sacrifices for the greater good of operational efficiency and streamlining and simplifying the system. I mean, what do you make of that argument, and how did you respond to it in the case?
You try and be professional, you try and not get totally worked up and frustrated and what to say to them, whether it's the legal team or whether it's the government officials. You go and live on benefits for a month. Yes, you go and be in my client's situation and just see the impact of it. So it's a line there's other cases which we might be able to touch upon that we've brought, and it's a line that's generally trotted out, automation at all costs, even at human costs, because it's this wider, greater good. But the reality was that in this particular situation just hadn't been taken into account by DWP when they'd actually been designing the system. UC itself, your payments, your people are paid 7 days after the end of the assessment period. If that payment date falls on a non-working day, then you'll be paid slightly early. So the UC system itself, depends on people not being paid on a non-banking day. So it's integral to the way employers and payers pay. But DWP, in the evidence that provided in the case, just hadn't taken account of the issue. And to me, it was very much a knee-jerk, after the event justification. Yeah, so we even got to the absurd situation where their counsel was arguing in the case, well, universal credit is about, trying to change behaviour, accepted. The main change of behaviour is to get people who are purely reliant on benefits off benefits. But their counsel was trying to argue that one of the changes of behaviour was to get individual employees to persuade their employers to pay them on a different date. Yes, and the court just dismissed that, just laughed at that. There's not an expected behaviour change. It's not for the individuals to be trying to sort out this problem. So yes.
And so how I know that the High Court decision was favorable to the claimants and basically asked the DWP to sort out this issue. And then the DWP appealed to the Court of Appeal. And what was the Court of Appeal's ruling?
So I just want to go one step back, which is looking at the High Court or the Divisional Court's ruling. So our case was brought on the basis of arguments around discrimination. So there's no right to an adequate standard of living. There's no economic social rights in the UK, but there's a right to non-discrimination in relation to welfare benefits. So we brought a human rights argument on a discrimination basis that sort of the differential treatment of people who happen to have claimed UC at or around the time that they are paid compared to somebody where there was no such clash between their UC assessment period dates and their pay dates. So we are arguing on discrimination. We were arguing on irrationality, the idea that this situation was just so unreasonable that no competent decision maker would have reached this point. And we argued on the basis that it undermined the very purpose of UC, which was to incentivize work. So those were the arguments that we brought to the Divisional Court. The Divisional Court went one step back and actually said, well, isn't there a construction or interpretation of the legislation point? So the legislation itself says that somebody's earned income should be based on the amount that they receive. And the Divisional Court emphasised the word based. So if it's based on the amount they receive, that's just a starting point. It means that in some situations, yes, what they receive, that's the end start point and the end point. But in other situations, what they receive might not properly reflect how much they've earned. And it was on that basis they said in relation to these particular clients, yes, what they had earned was not the same as what they actually received. They'd been earning on a monthly basis. They hadn't earned double the amount in one particular assessment period just because the amount they received was different. So it went for an interpretation argument. And that would have been beneficial. If that had been maintained, that would have been beneficial to other cases and other issues. Before the Court of Appeal, they didn't accept the construction or the interpretation point. So Secretary of State won in that aspect. But they did find that the decision not to come up with a solution to this particular issue was irrational. They looked at the impact on the claimant groups, so my clients and others affected by the issue. They looked at the impact on them, the oscillations, the loss of the work allowance. They looked at the impact on Secretary of the Department for Work and Pensions of trying to come up with a solution. And then they looked at the overall balance. And for me, as well as the judgment, which, as you say, goes into quite a lot of detail about the impact on the individual, so very personal in that aspect and a very useful counter to the government, well, this is a hard situation, just essentially suck it up approach. As well as that, the Court of Appeal heard argument from the Department for Work and Pensions that, well, if there isn't an identified solution to this problem, you can't find it's unreasonable not to come up with a solution. There needs to be a worked out solution before you can say that it's irrational. Because otherwise you're assuming there's a solution, and if there's not, how can it be irrational? And in response to that, the Court of Appeal said, okay, we accept that there's potential concern, but despite the sophistication of this whole computer system and the complexity of it, we cannot accept that the solution could not be derived. So they didn't require an actual solution to be formulated. They took a common sense approach that there must be a solution to address this issue. And in fact, they were found, subsequent to litigation to be correct. But it's that in the face of arguments that while it's just too overwhelming, it's too complex, it's going to cost 7.35 million to fix, it requires a complete rewrite. They weren't prepared to accept that. And in relation to the wider issues that this series of talks is talking about, that's critical because it's very difficult to understand or to get information about how the UC computer system works. Yes, there's very little transparency. In the course of this litigation, no information along that line was provided. In giving the figures as to how much it would cost, it wasn't explained what would be needed to be done and how that figure was derived at. So, if it had been on the claimants to try and come up with a solution, that really is, something of a Goliath situation, because we just don't have access to the information to be able to work out, come up with fully worked out solutions.
Right. And just to kind of, for non-lawyers out there, am I understanding correctly that the way the Court of Appeal decided was that, no, the government didn't interpret the statute that governs calculation of income under universal credit wrongly, but the way that it applied its interpretation was so irrational that it needed to make a fix for this particular group of people. Does that sound right to you, Carla?
Yeah, so essentially the legislation treating the amount that you actually receive as your earned income was lawful, but it was unreasonable or irrational not to come up with a particular solution or fix for this finite group of people, this cohort of individuals, just because of the extremities of the situation they found themselves in. And
it turns out that reasoning is actually a double-edged sword, and I want to get to that. But before I get to that, what happened after the court ruling? Was that ruling implemented immediately? Are the claimants that fall within that are covered by the ruling, are their issues sorted? Do they receive kind of a steady universal credit income based on a revised calculation of their earnings? So
we'll address all of those questions. So in some ways, the Court of Appeal was quite interventionist in terms of its reasoning, in terms of its sympathy for the individual claimants, in terms of it not being prepared to just accept this argument, well, it's just too complicated to address. So in that sense, it's prepared, to intervene and not just take Secretary of State's word. But in terms of, constitutional separation of powers, in terms of the order it made, it didn't see it in its power to say, right, this is exactly what you have to do. And this is a time frame in which you have to do it. So the actual order that came out from the court was a declaration that the provision in the law and the lack of solution or fix to address this particular group was irrational. And that was it. It was just an order, irrational. And then it became for the Secretary of State to decide what she was going to do to implement that judgment. And ultimately, it resulted in amending regulations. So it's a piece of legislation to amend the regulations and to give her the power to attribute one of the monthly wages to a different assessment period. So that was the fix. But so the Court of Appeal ruling was in June of last year. The amending regulations were laid in November. Yes, you got a 5-month period in which, as the law stood, people were still being affected by the issue. Fortunately, as well as this High Court and Court of Appeal route of challenge, also in relation to welfare benefits, you can bring something called a statutory appeal, which is, separate routes of challenge. And in relation to people who are bringing appeals, the tribunals were saying, okay, the court has said, Court of Appeal has said that this is irrational, and therefore we can't apply the law as it currently stands. So people were being able to benefit from the Court of Appeal judgment, essentially by a back route. The big problem for us was that not only the amount of time it took to amend the legislation, but then when the legislation was amended, it wasn't an automated fix. It was a manual fix. So it was dependent on individuals. When they saw that, oh, this month I'm getting a lower UC award, oh, that's because I've got that's because I paid slightly early. It was dependent on them to then post something on their UC journal to say, this is what has happened. Can you fix it? And the responses to that just was so dependent on who picked up that UC journal entry, yes, and so although training was meant to have been provided, it was so hit and miss, and repeated situations where you got people being told, well, there's nothing you can do. That's what the real-time information system says. You earned, there's no, you can challenge the real-time information system, but there's no other basis. And of course, it wasn't actually a challenge to the real-time information. They had received 2 lots of wages. The issue was that, well, they shouldn't be being treated as receiving 2 lots of wages. So this continued, and we got individuals contacting us, and we'd contact DWP to try and sort it out, or people would bring appeals. And this was going on until August of this year, when an automated solution was established. But having said that, even yesterday, I was in contact with DWP on behalf of a very distressed lone parent, again, 22-year-old, she got a 2-year-old boy. She was affected by the issue post the automatic solution. And her entry on her UC journal was essentially, this shouldn't be happening to me. These are the regulations which say it shouldn't be happening to me. This is, it's been automated. And the response to that was essentially a phone call from UC to her. She was taken off guard. It was when she was in the car with her young boy. The lady in the UC didn't seem to know what was really happening. And so this individual burst into tears just with the stress of the situation. It's already happened to her 3 times this year. And so the UC call handler then decides that, well, she's vulnerable, and I shall make a direct payment to the landlord to try and address your budgeting issues. So again, the total disconnect and lack of awareness of the changes to the legislation, lack of awareness of the automation, and lack of appreciation of the impact on individuals is something that the department, has been told to sort out, and well over a year on from that, people are still falling through the cracks.
Yeah, I also think that really speaks to not just the limits of, the courts, but also the limits of automation. Even an automation designed to fix the original problem can really fall short, and requires kind of broader social and cultural reckoning with how we approach, people who access benefits. Before I go to the audience,
but just on that point, Alice, it's right that there are limitations in the law, and I just like to stress that I'm not into litigation for the sake of litigation. If we can try and reach a solution and a dialogue with DWP, I would much prefer that to then have to take them to the court. So I brought the circumstances of this most recent individual, I brought it to their attention in the idea, I'm giving this to you as an example of somebody who's fallen through the automated system. What's your monitoring and evaluation to make sure it doesn't happen? But unfortunately, the nature of litigation in the UK at the moment is such that it's so polarised that trying to open those channels to have a constructive dialogue about the issue, as an organisation, we see people on the coalface. DWP, policymakers don't necessarily, can we try and discuss? The doors are pretty much closed to that, which is really unfortunate. And then it means that you have to get into the courtroom where things are immediately, defensive because there's only one winner, which then just creates this vicious circle of non-communication with each other on the wider issues and the impact on individuals.
Yeah, and so one last question for me, which is, you mentioned early on that it's not just people with regular monthly income that could be affected, but people also on 4-weekly, bi-weekly, and other formats of income. And I'm just wondering, I know that there was a decision, unfortunately, that wasn't quite as favorable. And could you explain what happened in that case and where you see us going from there?
Sure. So when the decision that we've been discussing, which is known as Johnson, when that came out at Court of Appeal, and a very well-reasoned and broken down approach to irrationality and what are the advantages and disadvantages and the overall balance, we saw that as a potentially positive model to be applied to other issues with universal credit. And that was how the lower courts saw it. So we brought a challenge in relation to somebody who was benefit caps, a limit on the total amount of benefits they can receive. And so the idea is that people are benefit capped to try and incentivize them to work. And so because of that, there's an exemption to the benefit cap if you're in work, but you have to be in sufficient work. And in universal credit, how it works is you are exempt from the benefit cap. So you're not subject to this total limit on benefits. If you are working 16 hours per week, earning the national living wage, and then that's calculated into a monthly amount. So times 52 divided by 12 to give it a monthly amount. So if your income, if what you actually receive through the ITI feed is equivalent to 16 hours national living wage times 52 divided by 12, you're not subject to the cap. But what happens if you're not paid monthly? What happens if you're doing 16 hours at national living being paid a national living wage, but you're paid every 28 days, every four weekly? In that situation, for 11 assessment periods of the year, you'll be slightly below the requirement for the amount to have been actually received to escape from the cap. And we won at a high court on the basis of the rationality analysis in Johnson being applied to this situation. Unfortunately, the Court of Appeal said that wasn't correct. Johnson was very much a very rare situation of a finding of irrationality. And we're now looking to see whether we can go to the Supreme Court with our case, because the idea that somebody is subject to potentially £500 loss of benefits each month purely because of how frequently she is paid, not how much she's working or how much she's earning, but the frequency of her pay, to us seems totally arbitrary and ultimately unlawful. If the divisional court decision in Johnson had been allowed to stand, which was your earned income is based on what you receive, but that's just a starting point, we can actually look at how much you're working, then this other case, which is known as Pantellisto, that would have been successful at both stages. So yeah, as you say, the Johnson case was a double-edged sword. It was obviously good to win it at both levels, but if the divisional court's interpretation approach had been allowed to stand up, then some of these other issues in relation to people with different pay frequencies would have been addressed as well. But in hindsight, because of decisions in other cases, it seems that Johnson is very much limited to its particular facts and that particular issue, as opposed to opening, wider avenues of challenge and redress in other scenarios.
So, on that note, one question we have from the audience is, what should people do when they suspect they're being disadvantaged by systems like this? Are there steps they can and should take? And I might want to add, in this particular context, given that we have kind of one ruling that seems favorable to making sure that claimants are protected, but another ruling in the Pantellisto case, which suggests that people with non-monthly incomes might continue to be disadvantaged. How should people affected by these systems appeal and challenge them?
It's difficult. I think this time last year, depending on a particular issue, I'd have said, yes, engage in the court system. Now, depending on what the particular issue is, I need to reflect on actually whether bringing a court case is going to be successful, and there's wider policy work that could be done. Obviously, if a person is affected by the particular Johnson issue, they can, they can appeal, they can ask for Johnson to be applied. But for other issues that are coming up, then there's concern about whether the judicial climate has shifted away from finding in favour of welfare benefit claimants and the difficulties that they're facing by the UC system. So the first couple of cases that we won in relation to universal credit, rather than starting, a trend, seems to have been very much, limited to their particular circumstances. We've at CPAG, and partly with funding from Digital Freedom Fund, we're working on some other cases which are about technical issues in relation to universal credit, and we're looking to bring them through the statutory appeal process, which I mentioned, so through the tribunals, where at upper tribunal level you've got judges who are social security experts, and that's contrasted to the High Court that I've mentioned and the Court of Appeal and the Supreme Court, where the judges across a broad spectrum of issues and they're not necessarily social security experts. And we're hoping that bringing cases which are quite technical in relation to aspects of universal credit through the tribunal process and having them addressed by judges who understand the complexities of social security and the way things have changed over the years, that we might be able to get some more favourable decisions from there compared to the trend that's happening in the administrative court and upwards. So there's forum picking as well.
Yeah, and one of the things that kind of really was compelling is when we were discussing about how people were really affected by the systems. One of the issues, and this kind of relates to one of the questions from the audience. One of the issues when we start talking about automation and the RTI feed and kind of the digital and automated aspects of the system is that it can very quickly become divorced from the reality of how they actually affect people. So one of the questions we got is, what can we do to counter this anonymization of the real people that are affected by these systems? And how do we get through to policymakers, legislators, and might I add, judges?
It's a really good question, and people say it's a really good question when they don't have an answer to it. So at CPA, the Child Poverty Action Group where I work, we don't just do litigation, we're involved in policy work, campaigning. We do case studies. So the initial client for the case that we've been discussing, she came through as part of a wider rough justice report and talking about different aspects of universal credit work which weren't working, and trying in that to put case studies and really make it concrete. I think the problem with that, though, although it will appeal to individuals reading it, maybe its impact on a system which has been set up is much more limited. And you get, as you articulated, Amos, you get counsel for Secretary of State in the case arguing, well, bright lines, hard cases don't make good law. And it's that total divorcing from the reality of individuals. And to me, it becomes a much more philosophical question. At the beginning of COVID in the UK, people put themselves in other people's shoes. Yes, they put themselves in the shoes of NHS workers, of key workers, and there was a lot of sympathy and there was a lot of realize, I can only do my job comfortably working from home because all these other people who I've usually taken for granted are going about their business, driving buses, stacking shelves. And there was a much more, a brief temporary feeling of coming together and community. And that's been lost now in the UK. And it's very much, this sort of them and us approach. And we're back to, being behind our dividing lines. And for however much DW might do stakeholder engagement, etc., I think it still is of the view that, well, we DWP are trying our best by people who don't really know how to do the best for themselves, that paternalistic attitude. And to trying to break down those barriers is really, really difficult. And within the court system in the UK, as I said, the statutory appeal system is slightly different, but within the High Court system and upwards, again, you're dealing with a judiciary who, most of them won't have claimed benefits. Very few of them will know people who've been on benefits. And that lack of empathy or inability to empathise, it just, I think, affects people. Yes, we talk about the objectivity of the law, but at the end of the day, if you don't fully understand the impacts on people, that will affect your approach to the legal analysis. We're subjective beings, so the more we can do to bridge divide and have people know different classes, different backgrounds intermingling, the better. But that doesn't seem to be our reality at the moment. We go behind our closed walls.
Well, Carla, this has been an excellent discussion, and you've given us a lot to think about and also a lot to work on, I believe. And I think our time is up, so I'm going to turn it over to Jonathan and the folks at DFF.
Great, Amos. Thank you so much. Thank you, Amos, for moderating this conversation and for your thoughtful and deep questions on this case. And Carla, thank you for taking us through, the detail of the case and the decisions that were handed down, and also for sharing the harrowing stories of those represented by CPAG in this action. It was a really great, detailed overview of a really complex case, and we know that the judges in the UK love writing short novels for decisions. So how you've managed to kind of condense everything down, a case which requires almost a PhD in maths to understand to begin with, has been really brilliant. So thank you both for taking us through that. Just a few final words from me. Please note that this webinar has been recorded, and the recording will be made available on our website and our YouTube channel soon. For those who want to revisit anything that was discussed today, and for those who couldn't attend today, please share the video as widely as possible. And as I mentioned at the start of this session, sadly, this is our final session in the speaker series. And I want to say a special thank you to all the speakers and moderators who joined us across the series, to the DFF team that helped them happen behind the scenes, and to all those who've attended and participated across all the sessions. We hope the series has been insightful and useful to your work. And like I said, we encourage you all to check out whatever sessions you might have missed on the DFF website, where you can find all the videos. So I'll keep to time. I know we promised to finish on the hour, so we'll call it a day there. And it's now safe to leave. Thanks again for joining us.